Okay, so your file. Well, I don't see anyone here. She's not on this matter though.
Oh,
I'm looking for their clients. All right, I've got some devices, so I'll have to find out who they are. I know it won't be that one because it says Michael's iPad. There's a Galaxy tablet. Let's see who that is. Are you both expecting your clients to participate? So I don't think this is Mr. Bynum, but I guess we'll find out. Honestly, it's been a while since I've seen him. I'm not sure I'd recognize him. Sir, what is your name? It's not connected yet. Can you hear me?
Yep, I can hear you now. I pushed the wrong button.
All right, that happens a lot. What is your name? I want to name the screen. And so when it's time to bring you in for your case, I know which one to bring you in on. What's
All
your
right.
name?
Name Travis Penza.
Travis Penza. Okay.
Yep.
Travis, I'm going to associate a name with your screen. And I'm going to put you back in the waiting room till I'm ready to call your case. Okay?
All right. There's a little bit of a lag, so it'll take me a second to hear.
It's all right. We'll figure it out. Okay, and let's see, I've got an iPhone. Let's see what that is. And this is, sir, what is your name?
Hello,
Yes, what is your name?
Larry Keith Bynum Jr.
Oh, okay. Well, we got you in the right place. So Mr. Bynum is present, but I'm not seeing your client, Ms. Denke.
That's
Oh, I'm sorry. Pardon me. So, sir, I'm not seeing your client. She can just dial the meeting number, and we don't need a video connection if she's having trouble making one. I've got it written down here somewhere. All right, we will wait till she arrives, and then we'll go on the record. So, Mr. Bynum, my apologies, but our courtroom camera is not working today. You will be able to hear what's going on, but the only person you're going to be able to see is me. and possibly Ms. Clark, if she ever manages to log in.
Yes, sir.
Karen's iPhone, there she is. Okay, and Ms. Clark, can you hear me?
I can.
Okay, our courtroom camera's not working today, so you won't be able to see your attorneys. I can assure you they're present. You will be able to hear them. So counsel state, Shannon, put us on the record, please. Counsel, state your appearances. Okay, so we've got plaintiff's motion to modify parenting time, and I think I've got a couple parenting time complaints by Ms. Clark. Oh, no, yeah, two, or maybe it's just one. They were sent over to me. A friend of the court normally addresses these first. They saw that I had a motion scheduled on the calendar and asked me what they'd like me to do. And I said, send them over. Let's get everything done at once so that the people don't have to show up to more than one hearing. So I do have two parenting time complaints by Ms. Clark. I can at least attempt to address them today. If more time is needed in order to fully address them with evidence, then I'll give you more time. So just so everyone's on the same page, Ms. Clark complains that on the weekend of, or I'm sorry, on December 18th, she was denied parenting time. Mr. Bynum pulled Jasmine out of school without my knowledge, took her to an appointment. I arrived at school to get the kids and Jasmine wasn't there. After calling Larry to inform him that it was my scheduled parenting time weekend, he was to return her to me. I explained to Mr. Bynum he had 1 hour to return her to me, or he is in violation and it is not his scheduled parenting time. The second complaint is for December 21st. Jasmine was supposed to be returned to me at 9 a.m. at school. She was not, and I had to leave work to go get her in Jackson. She was not with grandmother, but with babysitter while father was at work. Jasmine's Christmas break was in session, and as it states, fathers to have Christmas break after Christmas for 1 week. He was trying to take 2 weeks. So those are the complaints. Let's deal with the matter that was noticed for hearing first, which is the motion by plaintiff to modify parenting time.
Yes, Your Honor. Particularly a couple different parties did meet last year ago when this court filed
Let me stop you for just a minute. I want to make sure you folks can hear him. Can you?
No.
That's what I was afraid of. Let's,
Is it the microphone? Is it me projecting, or is it the technology?
well, it's, the real problem is our best camera and best microphone and speaker are connected with the Polycom. When the bandwidth is being used by other courtrooms, I can't turn the Polycom on. And so these folks are left with trying to hear you over my microphone for my pickup, my microphone on my desktop. And if I knew where that was, I could at least turn the computer to you. This is convincing me that in the future, either everybody's in person or everybody's by Zoom. If everyone was on Zoom this morning, everyone would be able to hear everyone else. I cannot count on that thing. They keep telling me they're going to get it fixed, and they keep failing. So here we are, and I'm trying to figure out a way to make this work so they can hear what's going on. They can hear me just fine.
I think the most pressing issue. So for the motion to start counseling, I think we can address more of this distinctly today. I think that's really the issue.
All right, I'll do my best to summarize what your counsel, Ms. Bynum, Ms. Clark is saying. He's suggesting that I need to conduct an evidentiary hearing on the issues related to modifying parenting time and parenting time complaints, which is, I need to hear from Ms. Denke before I make any comment on that issue. But the other thing, and therefore, he's suggesting that we put off till a time when I can actually take testimony addressing those issues. But he does want me to address today the issues of counseling because that appears to be more imminent. So I'm going to hear from Ms. Denke now on those issues. And I will do my best to summarize what she is saying so you folks know what's going on. Go ahead, Ms. Denke.
Your Honor, we filed the motion regarding counseling. Part of the mediation order was that my client could enroll they needed to agree on the counselor. We provided at mediation. I'm just that big. We got right that time. They did come back saying, we don't want her going to Hillsdale. We responded that if the counselor has offices in Jackson, she would be going to Jackson. He's over at the healing place, and he is available during my client's hearing. My client has midweek hearing time, which is Friday and the weekend. He's fairly limited in terms of trying to find a counselor to make that schedule. Followed up with that. Finally, my client attempted to address the issue a few times. Every time she didn't have time to talk about it, she had to look into it, and she came back. So he finally gave up and scheduled the appointment. The only objection he had ever received was he was down in Hillsdale County. Jasmine went to one counseling appointment. Let us know about the counseling appointment. She then canceled the January 2nd appointment and came up with three proposals. But they've also insisted that my client do all the transportation for counseling. He lives here in Jackson County. So to try and find a counselor that he can get to in Lenawee County, drag Jasmine back during their hearing test, Jasmine Lenawee to counseling. There was no objection based on Mr. Clinton's qualifications or anything else. This morning, when Mr. Simpson said, well, your client has so we're not comfortable with it. I've been attempting to reach my client without success to confirm or deny that.
Okay, folks, the issue presented to the court is that there's a dispute over who the counselor is going to be and where the counseling is going to take place and who's going to be responsible for transporting the child to and from counseling. So let's first of all talk about where do your clients live?
Your Honor, Ms. Clark lives.
All right, I'm familiar with the location.
And I believe he lives in Central Jackson.
So someplace close to Hidden Lake Gardens, ma'am?
A little bit closer.
Okay. And Mr. Bynum lives where?
He lives here in Jackson.
His new address.
Hi, the Jackson area is fine. I don't need to know the exact address for either. I wanted to get a feel for the transportation issue. And Jasmine is the only child at issue here
That's right.
for purposes of the counseling.
Yeah.
Okay, how old is Jasmine? Everybody agrees she needs counseling.
My
Yeah.
client stipulated just think it's needed, no, just think it can help.
What kind of issues is the child having that would be addressed in counseling?
Judge, Jasmine is, the parents can have very different rules and understanding of what should happen in the household. And Jasmine is very upset about things. She'll announce that she's not allowed to call her, she has a half sister. She spends a lot of time with her half sister and half sister. She's not allowed to call me. She's not allowed to sit she'll get upset when people are allowed to, her sister is not allowed to come to her house with her mother. Or that most recently,
All right, so you're telling me what you believe is causing her to have problems. I want to know what the problems are.
the problems are a lot of anxiety, a lot of time,
Okay, that's helpful. Thank you. Where does Jasmine attend school? Lenawee Christian. I'm familiar with this. So mom lives pretty close to the school. Dad lives, well, I know how far it is from Jackson to Lenawee Christian.
About 45.
my client is not.
Part of our problem. Part of it is for. Option. So there was availability to her. All she ever wanted was that if she's going to give her time, then he can come down. Come up to Jackson, it should be his time. It wasn't until very recently we even found out that he withheld the fact that this counselor who he's been pushing for since August, he goes to this place and has been for apparently years as a counselor himself. So she's a little distrusting, and understandably so, when you withhold the information that it's your counselor, that you see a person at this place that's readily familiar with the area, and you don't tell her any of this stuff. So now she's feeling like this person is biased or would otherwise have preconceived notions or information that isn't fair representation of what's going on. child. So yes, we have an objection. We can find another counselor. We've been offered only that one option where we've given three.
Judge, they gave their three December 22nd after Jasmine's
Not-
hearing.
One at a time, counsel.
The email that she sent with the three proposals is attached to their answer. So, and it's dated December 22nd. And the first time I heard, well, he goes there, was today, that wasn't in their objection. The only objection they've ever raised was his office in Hillsdale, which isn't accurate. My client does not see that therapist. Is it helpful to have the therapist that he sees and Jasmine sees in the same office so that are their colleagues so that they can work together on how my client can better handle issues with Jasmine? This is absolutely that's appropriate. She's welcome to be involved, but as the mediation agreement makes clear, this wasn't really her thing. My client was the one who was given permission in mediation agreements from it.
So, I'm familiar with a healing place. I deal with them a lot. We get psych evals for parents and abuse and neglect cases done by Dr. Lauder, who's the head of that. They have lots of counselors on staff over there. The fact that Mr. Bynum sees someone else at that agency, I mean, I would agree if he was wanting his counselor to counsel the child. There are boundaries there that would be violated. And I would expect the counselor would say, I can't do that. But fortunately, they've got lots of people available.
And this is, we just learned that it's not the exact same counselor now. We're not getting communication. What's really, he speaks in half measures, half truths. It's frustrating.
If they put it in their answer, I would have done.
Had we not, if we known about it when we filed an answer, we would have addressed it in our answer. But she finds out information secondhand. It's secret. We found out that he got evicted secondhand. We find out he's been living in a hotel for the last 8 months secondhand.
Right. They subpoenaed the information from the department, so they have the paperwork where he told them he was not renewing his lease. So why they're suggesting that he got evicted when in fact he chose not to renew his lease is unclear, speaking of half. They got the paperwork.
He got evicted. He said he couldn't afford rent. So he submitted a notice. I'm saying we learned about all this stuff, not from Mr. Bynum talking to the mother of the child, where they're communicating, say, hey, I'm just moving from here to here, which is what you should have done. You have to find out about it secondhand, and if she was subpoenaed to find out whether it's true, we won't get that correspondence. That's really where the breakdown is too, is that they can't communicate. And so when we find out that there's a counselor, that he's been seeing a counselor, we don't know it's the same, there's no healing place.
Why would I have to tell you I'm seeing it?
Your Honor, that there are separate counselors in there. We're aware of the healing place. We didn't know. There's a lack of communication across the building, and it's part of that communication. I believe they're supposed to be using our wizard. If they're not, I would suggest that that be a way to
The fact that I've got a file as thick as this one is tells me that there are communication problems. That doesn't come as a great shock to the court. You know, I've probably given these folks the same lecture I give every other divorced, separated couple about how important it is that you're able to put your personal differences aside and have open communication for the good of your child. And some people hear me and some people don't. But the reality is here, now that I've heard, I think everything I need to hear about the counseling, it makes sense to me that the child continue with Mr. Clanton. It certainly makes sense if Mr. Bynum is the one who's going to be transporting to and from the counselor, that the counselor be in the community where he is, since he has limited parenting time to begin with. As to that issue, Mr. Clanton can do the counseling. Certainly at any time in the counseling, if it appears, and I want both parties to have full access to Mr. Clanton, to be able to discuss. If mom wants to, if Mr. Clanton wants to involve mom in the counseling at some point, just simply to address an issue that can be addressed better with a parent than it can with just the child. She needs to cooperate with that. And let's at least get that piece moving. She's already seen him once. If she hadn't seen him already, I might have a different response, but she's already seen him once. She's already begun to at least to develop some kind of rapport with his counselor. Let's let Mr. Clanton do it. The fact that there's someone else that dad sees in the same office is not concerning to the court at all. In fact, it's actually easier sometimes when we've got multiple issues going on that the counselors can talk to each other if they see a need. So let's at least get that resolved. Ms. Jenke, you did not speak to the issue of an evidentiary hearing and the need for one.
I would suggest that taking a parent from essentially a 50-50 schedule down to a weekend schedule is in fact a change of custody, and they have not presented the court with sufficient changes in circumstances to proper questions to change custody. So I don't think they've met the threshold to get an evidentiary hearing. I don't think one is necessary. The argument as to whether seems to be close to, she's in kindergarten. And my client's work schedule, which they incorrectly indicated, nights and weekends, he works from 4 a.m. to noon on a rotating schedule. I don't think that we're going to change that. And we're to make sort of an evidentiary. What wishes to hold an evidentiary hearing, as we've indicated in our answer. If we're going to open that door, my clients would like to have
We're not asking for it. Perhaps 3 weekends during the school year. We already get off most of the summer. Most of all the holiday breaks. Any Monday that the children are off in school. We equalize this. Child goes to school in one. And that's really what that was about. There's no possible way knowledge is delayed with them living in Jackson and her living in Adrian, where you really have a sense of community for a child without going to even social aspects of the child. Connecting with people, classmates, becomes discombobulated, not connected. So the parties agreed. They agreed to arbitration. So we altered the schedule. We did 3 weekends a month, Friday to Monday. Our biggest problem is then the whole reason he wanted to deliver on Monday, drive from Jackson in the morning to Adrian, was he wanted that time to commute. We said that makes sense. Absolutely right. You had that connection. There's a lot of habits in the car. The problem is it hasn't happened. He doesn't take it. He has his mom take it. She's at work. So why not deliver her Sunday nights when she's rested and getting up at 5 o'clock in the morning to go over to school? Why not she has nights when she has all of her stuff together? As they've already argued, she has anxiety issues, she has some comfort issues, she wants to make sure everything is particular in her Africa. So we're asking to modify that. If you look, we previously filed right before this, before modification, we asked to enforce the term. They can do it. The whole reason for the Sunday night was that he could drive her, but he wasn't doing it. And they stopped at that, saying that's not really what it said. It said that he can pick whoever he wants. That wasn't the intent. That's okay. What was intended was for him to have that. All we're asking for is to modify
Who was the mediator?
that.
So I've got two parenting complaints here that I'm going to have to address. I've got to take some testimony to address those unless they're completely undisputed. I think that what council has described, if true, is enough of a change to justify revisiting, tweaking the parenting time schedule. I agree with you. I wouldn't change the parenting time schedule in a way that results in a change of custody. I don't believe we're anywhere close to that threshold. But tweaking. So here's what I'm going to do. I'm going to order that there be an evidentiary hearing on a motion to modify parenting time and the two parenting time complaints that I have, and any new parenting time complaints that arise between now and then, so that we're addressing everything at once. And I'm going to order that all of those issues be returned to mediation with Mr. Hotchkiss before a parenting time evidentiary hearing takes place. Yeah.
Okay.
And Judge, if the court wants, I can address the training time.
No, let's just do everything at once. I think that makes sense. And folks, I don't know if it's going to fall on deaf ears or not. I can pretty much assure you, if your daughter's expressing anxiety, a big part of that anxiety, I can guarantee you, is attributable to your inability to communicate civilly with one another as concerns your daughter's best interest. Divorce and separation are hard on children. They just are. They can't process it. It isn't a question of who's right or who's wrong. It's a question of what does she need? What does Jasmine need? Jasmine's got two parents who obviously love her dearly. I can see that. And I suspect she probably loves each of you dearly. I don't doubt that for a minute. But getting involved in a tug of war, it's just not good. It just isn't. And you have to just come to terms with the reality that Jasmine is living in two households, and two households that have parents in them. And being in a household where someone who's acting in a parental role is not being treated as a parent is not good for her. I hear some people approach this by saying, well, you've got two mommies, you got two daddies, or whatever. But trying to drive a wedge between Jasmine, and I'm not saying somebody's doing that. I know it's been alleged. I don't know what's true. Or I can say, driving a wedge between your daughter and your ex's current spouse or partner isn't going to do her any good. So please, please, please think of your daughter before you engage in this tug of war. You got to figure out a way to communicate. You've got to figure out a way to work together. I hope you can learn to do that. Who's going to prepare an order for?
I just want to make sure I'm clear. So that on a counseling order, on the evidentiary hearing, you'll package the
Yes. Okay, thank you, counsel. And next time, unless the courtroom's open, you're both gonna have to figure out a way to do it by Zoom. This isn't fair to your clients. I mean, it would have worked if my technology worked, but I cannot count on it. Okay,
I had offered with Mr. Finley, or
Well, and I didn't even think of this. I should have. I should have realized that when my polycom's not working, the parties who are far more important in this case than their attorneys are, no offense intended, deserve to hear what their attorneys are arguing. I can tell you that both of your attorneys did an excellent job today. You're both well represented. And
Thank
we'll try to make sure this doesn't happen again the next time we have to show up in court. And hopefully you can work things out. You don't have to come back. This is the last place, the worst place to get things resolved, because you ultimately put the decision in my hands, and I try to do what's best for the kid, but nobody knows what's best for the kid better than the parents. So I hope you take this to heart.
Thank you.
Thank you.
you.
Okay. Let's see. Good morning, Ms. McCluskey. How are you today?
Good morning. I'm doing well. How are you, Judge?
Doing well too, thank you. Okay, this is Tedders versus Tedders. Let me see what I've got here. A lot of people waiting out there. Ms. Tedders' name is still Tedders, as far as you know.
All right, Colleen. I believe it is.
There's nobody logged in by the name of Tedders.
Okay.
Are there any other attorneys involved in this case, to your knowledge?
Nope, not to my knowledge, Your Honor. I have communicated with Ms. Tedders. Obviously, I just subbed in for Mr. Fabian. It was his understanding that she would possibly not participate. My client was going to participate, but he does have patients, so he may have had to log off. If the court has no objection, I would waive his appearance. I do think it's pretty straightforward what this was set for hearing for, so I'll leave that to the court's discretion.
All right, so an ex parte order was entered quite some time ago.
Mhm.
And did Ms. Tedders ever file any opposition or show up to oppose this?
She did not. She did not. I know Mr. Fabian had a conversation with her. It's my understanding, well, she has not seen their son in over 3 years now. No contact, no attempts to contact, no birthday cards. So it was my understanding from Mr. Fabian that she indicated to him that she was not going to oppose that motion, I'm sorry, the order, and she did not file an objection to that. So Mr. Fabian, I'm not sure why a review of support wasn't done at that time. But he did set this for hearing, essentially only to request that the court order a support review and backdate to the date of the filing of the ex parte motion. Obviously, my client has custody of the child and has for 3 years, so we just obviously want to stop his support obligation and recalculate support based on the current order that's in place. And to be honest, I called the front of the court twice. They've left messages, not gotten a return call yet. The parties may have a right to a statutory review. I don't believe support has been reviewed in the last 3 years. So, I mean, that could it could be referred to the front of the court for that purpose.
Yeah, I don't think whether or not there's been a support review in 3 years matters. We certainly have a change in actual physical custody, and that merits a support recalculation consistent with the custody arrangement that currently exists, and I will order that. If you'll submit an order, we'll refer the matter to the front of the court.
That sounds good. Thank you, Your Honor. Will do.
Thank you, sir. Keep you waiting.
Have a good day.
You too. Oh, did she say where they found it? Okay. All right, let's see. Roth versus Penza. Mr. Rosenthal in. Well, I don't see him. Oh, this might be it. Michael's iPad. Morning, Mr. Rosenthal.
Morning, Your Honor.
Let me suggest to you for future hearings, you change your login name so I know it's you and not some other Michael.
I never even noticed that. Sorry. I used to use my wife's and she's familiar with the Apple stuff. I'm not. So I just never even looked at that.
All right, no problem. I see Mr. Penza's here. Let me get him in. And let's see if Ms. Roth is here. Doesn't appear so. Have you had any contact with any attorney?
Yes, Mr. Rapley represents Miss Roth. He filed an answer.
Well, the answer didn't make it to the file and there's nothing to indicate that, but I see Mr. Rapley's here. Let me get him in. Good morning, Mr. Rapley. This is Roth versus Penza. Mr. Rosenthal just informed me that you had filed an appearance and an answer. It wasn't in my copy of the file, so I didn't immediately bring you in. And I was looking to see if your client is out there, and I don't see.
She's in my office.
Oh, okay. Well, great. All right. So here we are, Roth versus Penza. And Mr. Rosenthal, this is your motion.
Thank you very much, Your Honor. And I believe the motion pretty much stands on its own. But with regard to what's going on here, Your Honor, this has been years ago when this parties first separated and there were issues with the child. Things have gone on, not good. Mom kept child from dad, whatever. Things were resolved. I think the last quarter was 2013. For the last 2 years or so, I'm going to say about 2 years, the parties have been pretty good about co-parenting. They've been getting along, doing a lot of things together. In the motion, we indicated that they were basically the kid was spending half the time with both parents. And adding up, and they do have a calendar that I do have. It was just a little too confusing to copy and send. It's not exactly half. That's correct. I believe dad had 162 overnights rather than the 48 overnights that he actually has pursuant to that court order in 2013. As I said, there's a calendar that he was keeping. There was also other times the child was with him, and including mom's other kids that were there at various parties, barbecues, and there's pictures for all this stuff. This was not a one-time event. They were actually getting along really well. Both parties, both families were getting involved. My client is remarried. He's been with this woman for quite some time. This child's known this woman since 2013. They all were getting along real well, and this child was spending nearly half the time with dad. Unfortunately, as of recently, something happened sometime in December, I'm going to say, that my client points to like a December 19th date when mom started dating some other man. And that's when really all the problems came around. Just to explain some things in the answer, mom claims that defendant was homeless and moved into a home. He lives like 8 minutes away now. He never was homeless. He rented an apartment for purposes, or actually he was in a hotel till the house got finished and he could move in. He was there for like days. He was never homeless, and they don't own a home owned by anybody's relatives either. They moved because they were spending so much time with the child. They were all getting, it just made sense. That's why he did it. And it's also important to note that his wife has other children who this child, Gavin, was very close with mom, very close with these children. They make an issue that mom's on Social Security for mental health issues and she was crazy, changing medicines. That's completely untrue. Mom has rheumatoid arthritis. Yes, she's changed medicines. As anyone who has arthritis knows, it's a combination of trying to figure out what works and what doesn't. There's no mental health issues. There's no issues at all. This child loves this woman, Your Honor. He looks at her as a mom. As I said, she's been in this child's life since I think the child was like 2 or 3, and the child's now like 10. So his stepmom's been in this child's life for a long time. They're incredibly close. Unfortunately, as of December 19th, things changed. Mom started keeping the kid from dad. Mom actually got it to the point where she would actually tell school personnel to not let the child go see dad or see stepmom and her children because he used to give them hugs. Just stopped it. She actually made the child stay in the car until they were in the school before she would even let him leave. And there was a reference in the answer with regard to photos that the child was taking. This child will confirm. That's why he took the picture. He was showing stepmom and his stepsisters were there. He wasn't allowed out of the car because mom would not let him have any conversations with regard to stepmom and dad, because dad would go too. He'd always run up, give dad a hug before school, see dad after school, because they were always there together with the other children. But for some reason, mom and my client doesn't know if it was a jealousy issue with the boyfriend, doesn't know what caused it, but suddenly things changed, and it changed rapidly. And since that time, it's just been an issue where there's been a constant wedge put between dad and this kid to where the kid is now actually suffering. Mom makes this child feel guilty. After, I would assume it was December 19th, the school got involved. The school actually saw issues going on with this child. And that's the end part of that motion. The school actually called both parties in to discuss these emotional and behavioral issues going on of this child. He was miserable. He was unhappy. He was upset. He was acting out. They brought everybody together, talked to everybody, tried to work out some type of situation to get this kid back on track because he was clearly suffering. It's believed the child was having communication issues with dad as well, in addition to not seeing him. Mom cuts them off, blocks him from the phone, doesn't allow phone contact. And understand, this child has been seeing dad 162 overnights a year to suddenly go to, you're just going to see him on weekends and when I choose to go see him, and that's it. And it really affected this child. This child is very close to his dad, very close to, as I said, stepmom and her kids. And mom just put a wedge in between these people, and it just made kid miserable. There's also concerns that mom's getting in the head of the child, basically telling them, hey, that's not your mom. Hey, those aren't your sisters. Those aren't your family. And this is having an adverse effect on the child. It's unfortunate. It's sad. And clearly this child is now struggling because of being yanked out of dad's life when he's been in it and so close to him and so involved with dad for the last 2 years, Your Honor. As I said, mom even asked the helper at school, because I don't know if the court's familiar with the way school works. Kids are released. They get released from school. There's usually a teacher or an aide there. Mom would ask the teacher's aide to basically say, don't let the child out as long as dad's there. Child goes to me only. Do not let him see dad, dad's family, anybody. I want that child kept in the school. Kid broke out eventually, went out, hugged dad. That was the end of that. But this is a sad situation that's now affecting this child mentally and emotionally. And things need to change, Your Honor. We need to change parenting time to the point where this child was back to the way it was before. As I said, things got so bad, school got involved. And as a result of that meeting, The parties are trying to work things out. Clearly they didn't, but the principal's willing to testify. Not only did the principal and the counselor meet with the parents, met with the kid too. And the kid is willing to come and testify if the court wanted to meet with the child to let the court know what is actually going on with regard to everything involved at mom's house and how this is just having a detrimental and negative effect on this child. And the kid's suffering. And as a result, we need some changes with regard to what's going on. Things are so bad, the kid will actually talk to the dad's dog and apologize to the dad's dog right in front of dad. I'm sorry, I can't stay with you. I got to go home. Your Honor, that's not right. That's not good. That's a clear problem going on with this child who's struggling with regard to mom and dad not getting along, mom and dad not getting able to work things out and not being able to spend the time with dad that he had been accustomed to spending with him. And those changes alone clearly show there's a proper cause and a change of circumstances to go from almost half the time to now, yeah, you're just going to get your every other weekend when I say you can see the kid. It's clearly a change that needs to be addressed. It's clearly a change of circumstances based upon just the mental effect on this child. And this child is truly suffering as a result. And I would ask the court to find this proper cause, set the matter for an evidentiary hearing. This way we can bring in everybody, the principal, the counselor, and the court could interview the child for purposes of getting to the root of the problem, what's going on and what this child is going through and what this child is suffering through. Your Honor, there's also a request with regard to mom cutting off the child's phone, blocking dad. That needs to stop too. Child needs to be able to talk to dad freely whenever he wants to, if he wants to. If dad calls, it shouldn't get sent away because he's being blocked. That needs to be addressed as well. And also, Your Honor, now that the school got involved in January, perhaps it's best that this child be allowed to see a counselor, a mutually agreed upon counselor for purposes of at least resolving some of these issues of how the child feels. The one thing that I know everybody learns in dealing with children, as long as a child feels that way, it's true to the child. That child is going through this. And this child needs some type of release because clearly mom and dad do not get along well enough for purposes of addressing the issues that need to be addressed for the benefit of the child. And I would ask the court to set the matter for an evidentiary hearing, addressing the issues of parenting time and custody, allow them to see a mutually agreed upon counselor and stop with the phone harassment and contact and not allowing this child to contact dad when the child wants to and vice versa with dad contacting the child. And I would ask that the court order those things for purposes of moving this thing forward and helping this child because this child is suffering.
Thank you. Mr. Repley?
Well, Your Honor, I'm a little surprised we're in court. My client sent a text message to the father on January 28th, before this motion was filed and signed, inquiring about getting this child in counseling, and he ignored it. So we got to come to court to get a court order for counseling. When mom reached out to dad as in his role as co-parent, and he ignores that. Kid should be in counseling. But like with any counseling, to change anything, pending the counselor's ability to establish a baseline, this serves this child no purpose. A counselor should be able to establish a baseline of this child in his current environment before any changes are made. Let me get to the factual allegations that I suspect came from the father. And I would note that prior to this motion being filed, my client had filed for a support review. So if you want to look at motivation for pursuing a change in parenting time, that would be it. Counsel in his motion stretches this out over a 2-year period. The reality is he moved into this house in Hillsdale County on January 20th of 2020. After COVID, in April when COVID affected the school, these kids had nothing to do. My client reached out to the father and his wife, and they arranged play dates for the kids. So commencing in July of last year, they spent a lot of time together. There's no dispute that we don't dispute that they participated in events and picnics and parties and things like that due to COVID. And so I'm struggling just generally with a parent who does what she should do and tries to maximize time with a child and his second family, or his other half, the other half of his family, and not to minimize dad's family here. But then that comes back and snaps her in the rear end with a change of custody. That's going to have a chilling effect going forward on anybody doing what my client had done over the last summer. If that's the risk of a parent in co-parenting and trying to maximize the total family unit for this child, is that she's going to get a motion for change of custody and things are going to change. People won't do that, Judge. People will go the opposite way. But the reality is that he and his wife lived in his grandparents' the basement of their home for a period of time. His wife got into an altercation with his grandfather. In fact, there's a police report on that. He was charged. They were kicked out of that house. They actually spent 3 days with my client. Then they went to a hotel. Then they were in a trailer. They were all over the place until they got this house in January. And then COVID hits. And my client would make an offer of proof that the time that we're talking about, these parties and spending a lot of time, my client would take the child over to his house because he had things in the yard that they could play with. So the three kids were playing together, and on occasion, the child would request to stay. There was no pattern to it. There was no consistency to it. It was just on occasion because he had been there all day spending time with these other kids. So what I would suggest the court do is allow the child to be in counseling. And I would suggest, because they're both in Hillsdale County, there's a good counselor that does a lot of work with the court down there by the name of Mari Nunez. She does a lot of work with the children in the abuse and neglect arena in the Hillsdale County area. Let her work with this child. Give her some time to establish a relationship, to deal with any issues that the child has, and then allow either parent to come back at that point, at some point in the future, and file a motion for change of custody. The problem is that with a pending change in custody motion, and if you set this for hearing in 2 or 3 months, everybody's going to be acting accordingly. That's not going to help this child. We're not going to get a true picture of this child's issues, if in fact any exist. So I'm suggesting that you allow the counselor to do his or her job and make recommendations. If the counselor thinks that it's appropriate to modify things, then give her that authority to make a recommendation. And until such time as she makes a recommendation, I would suggest that either party can come to court with that recommendation. But to have something pending, Judge, everybody's going to be operating with the fact that there's a pending hearing and things are not going to be normal for the parties nor this child. Thank you.
Mr. Rosenthal, anything further?
Just real briefly, Your Honor, the problem with setting this over and just saying, oh, let's let a counselor take care of it. They tried that. They actually reached an agreement with the school counselor, with the kid present. Didn't work out. Mom changed her mind. That's the problem what's going on here. And the fact that the child they don't deny the child was spending all this time with dad. That's created the environment, the custodial environment with both parties. And to argue that, well, then a parent won't let that happen. Fact of the matter is, dad's a good dad. That's why that happened. The child has other step family there. That's why that happened. That created the situation where child has an opinion. And if we look at the law is best interest of the minor child, not the best interest of mom, not the best interest of dad, the best interest of the minor child. Clearly there's a change here. Clearly something's going on. If we set this matter for an evidentiary hearing and allow the child to go through a counselor, it doesn't affect how people act. And if we're going to say that the court hearings are going to affect how people act, then clearly the court needs to take action anyway, because they're only behaving, quote unquote, for purposes of, oh, there's a pending court action.
All right, thank you. Here's what I'm going to do. I am going to order that the child immediately begin counseling. The counselor that Mr. Rapley suggested will be fine. I will set the matter for an evidentiary hearing. Clearly, we have some vastly different view of the facts. If Mr. Rapley's portrayal of the facts were true, I would agree. I shouldn't set it for an evidentiary hearing. But I can't conclude based on the radically different state of affairs described by Mr. Rosenthal that that is true. The only way we get to the bottom of disputed facts is by having an evidentiary hearing. But pending the scheduling of an evidentiary hearing, I want the parties, if indeed the counselor is able to make a recommendation, I think that'd be great, but I'm a little concerned that the counselor might have an issue with crossing boundaries. If the counselor can make a recommendation, great. But if the counselor says that I'm not going there, that's not my role. My role is to help this kid process what's going on. I think what we need to do is get a LGAL involved. The parties will split the expense for the LGAL. If you can't agree on who the LGAL will be, let me know and I will pick someone. That LGAL, I'm also authorizing to serve as a mediator so that once he or she gathers whatever information is needed and ferrets things out and talks to the child and perhaps even talks to the counselor, can also serve in the role as a mediator. And that process needs to run its course before I'm going to take any testimony and schedule an evidentiary hearing. I'll have Dawn set a date approximately 3 months out. Mr. Rosenthal present an order, just put in a blank for the date of the hearing and I'll have Dawn supply that.
Your Honor, if I may, just to clarify, with regard to counseling, I didn't actually get that person's name, but is that going to be equally divided? I don't know if that's covered by anybody's insurance. So I don't know if that's going to be equally divided as well.
Well, it won't be equally divided. To the extent it's not covered by insurance, it'll be shared in accordance with the current support order. If I ultimately modify support, modify custody, and support gets modified consistent with that, that might change the percentage because it's going to be retroactive to the date that Mr. Rosenthal filed his motion. But any portion that's not covered needs to be split according to the support order for any other non-covered medical expense.
Okay, and I'm just throwing it out just to avoid conflict with these parties. I think Mr. Penza has every other weekend from Friday to Sunday. I don't know if the court would consider just letting it go to Monday morning so that these parties don't even have to see each other during an exchange at school.
Your Honor, there's no allegation that there's any.
I'm not going to order any change.
That's fine. I'm just trying to avoid
certainly
conflict.
I get that. I would strongly encourage the parties. You see that your child is having issues. These issues are being caused by your behavior, parents. I don't know which parent is at fault because I haven't taken testimony yet. But put your child first. This tug of war isn't doing him any good. All right, Mr. Rosenthal, we'll watch for that order.
Great.
Your Honor,
Thank you very much, Your Honor.
One more thing, Your Honor, the LGL, could that be a Hillsdale County appointee only because the parties are down in Hillsdale County and saves them the cost of transporting the child and or themselves to Jackson?
If you can agree on someone and you can find someone you both agree on down there, sure. If
Thank
you
you.
can't, then if you can't agree, I'm going to pick someone. I don't know any of the Hillsdale attorneys to be able to tell you whether or not I think one would be good or not. But if you can't agree, you certainly can make recommendations to the court. And I will consider among those that you've nominated.
All right, thank you.
Thank you very much, Your Honor.
Thank you. Well, is everything going to be like this morning? Could be here a long time. All right.
Am I leaving me?
Okay, there's Mr. Conant. Let's find Mr. Navarre. There he is. And let's see.
That's a stop.
Daniel Clay is here. Let him in. And Kelly Roth, there she is.
Good morning, Your Honor. I can see and hear you.
Good morning. I'm waiting for all the audio connections to come through. Ms. Broad, can you hear me?
Yes, Your Honor, I can.
All right, so we're just waiting on Mr. Clay's connection. So this is Clay versus Brodt. Mr. Conant for the plaintiff, Mr. Navarre for the defendant. Ms. Brodt is present, and we're trying to establish a connection with Mr. Clay. Looks like we're getting closer.
How you doing, Your Honor? Can you hear me? I'm sorry. I'm just trying to get I was just handling some online schooling and making sure they're handling their Zoom meetings and all that. Sorry.
No problem. So I've got everybody here now. And we're here on objections to the front of the court support order recommendation. Well, I guess it addresses parenting time as well. And let's see, Mr. Navarre, these are your client's objections, correct?
They are, Your Honor.
Go ahead. Mr. Conant, if you filed something and it didn't make it to the court file in time for me to see it.
Oh, my
So
goodness.
I'll need to have you address. I don't know what your practice is, but let me recommend to you, given the serious issues we have with the mail these days, don't rely on the mail. Whenever you're filing a motion, and particularly a response, a motion not so much because there's more time, but the response to the motion, email a copy to Dawn and to Peter. That way we'll be sure that I get a chance to read it ahead of time. But I'll give you ample time to set forth your position.
I haven't received a response either.
Good Lord. Mailed it out on the 5th.
Well, no, I think email's a little bit more reliable.
Yeah, I can tell you with certainty the mail is not reliable. Don't rely on it. Even though the court rules require you to do these filings, I would always follow up with an email. That way we know we've got it and everybody has it. So go ahead, Mr. Navarre.
Thank you, Your Honor. Your Honor, the front of the court in the recommended modification of support failed to take into consideration an accurate number of overnights for my client. They utilized 52. And that's not consistent with what her current court order parenting time is. They used the improper amount for the annual ordinary medical. And Logan's in 5th grade. He's going to be 12 in May. And Melissa's in 3rd grade. They're both going to Hunt Elementary. She'll be 10 this May. And we stated in our motion that the handbook through Jackson County Front of the Court, which was updated April 2011, defines reasonable rights of parenting time to which both defendants and my client and the children are entitled to. And the reasonable rights of parenting time affords 85 overnights. And so that's our position, that she should have at least reasonable rights of parenting time as outlined in the handbook. She recently exercised half of the Christmas break, Your Honor. She should be afforded spring break and summer break parenting time pursuant to the handbook. And MCL 722.27A1 creates a presumption that it's in the best interest of the children to have a strong relationship with both of their parents, and that parenting time shall be granted to a parent in a frequency, duration, and type reasonably calculated to promote a strong relationship between the children and the parent granted parenting time. And Michigan law creates that presumption that it's in the best interest of the children to have a strong relationship with both parents. Both children have expressed a preference to have additional parenting time with their mother. And back in March of 2017, my client was in pro per. She stipulated to an order changing the situation, parenting time, because her upper duplex rental residence was condemned by the city of Jackson, and that was caused by renters in the lower unit of the duplex operating a meth lab. And her housing was displaced, and she was unable to secure suitable housing. During that time, over a significant period of time, she was using her limited resources to rent rooms at hotels to exercise parenting time overnight with the children. She does have suitable housing, and she's residing with her father-in-law, and the children enjoy spending time there. It's her position that it's in the children's best interest for her to be awarded at least reasonable rights of parenting time as outlined in the front of the court handbook. And so she's asking for that modification. It's not going to change the established custodial environment. The court would be looking at a shade versus right standard, and we would ask that the court grant her request for modified parenting time commensurate with the reasonable rights of parenting time outlined in the front of the court handbook, updated April 2011, and that the court then order that support be recalculated based on the proper number of overnights with the PTO.
Thank you. Mr. Kodak?
Well, first of all, I don't know whether council even paid a filing fee for a parenting time modification motion. He tried to
Paid $100, Dennis.
Okay. Well, you kind of slid it in with this motion objecting to the front of the court. But what I want the court to understand is that we filed a motion for retroactive modification of the, for modification of the child support, and that was filed March 5th, 2020. So the front of the court's acting pursuant to that request, that the review is completed January 6th, 2021. Council's objected, I guess his objection appears to be timely. The defendant was calculated by the front of the court her actual overnights, contrary to what defendant has indicated. The front of the court completed the annual ordinary medical contrary to defendant's statement. The plaintiff's son is in the 5th grade, and the daughter is in the 3rd grade. That the reasonable rights of parenting time is determined by what is in a child's best interest, not by what a child is entitled to. The front of the court handbook has recommended overnights where it is in the child's best interest. Unfortunately, defendant's home is not a suitable environment for the children due to defendant's instability to create a safe environment for her son and daughter. The front of the court only sets general guidelines as to what is in a child's best interest. It may be less than 85 overnights. And in defendant's situation, it definitely needs to be limited in terms of overnight parenting time. That over the Christmas 2020 break, defendant did exercise one half of the break. However, it was not a healthy situation for the children. That based on defendant's actions over Christmas break, it would be unwise for a defendant to exercise spring break with the children. That if the best interests of the children are taken into account, defendant should not be provided parenting time. MCL 722.27A1 does presume that it's beneficial for a child and parent to have a strong relationship. However, when a parent's environment and parental decisions are harmful to the child, then the court needs to deviate from the basis set forth in the statute. That the parenting time statute sets forth criteria to be considered where appropriate, but in each case determining what's in the child's best interest. The children have expressed opinions ranging from wanting to spend time with defendant to not wanting to spend time with defendant. That by way of history, January 8th, 2016, and the order was changed in the best interest of the minor children to grant plaintiff the primary physical care on 3/2 of 2017. That defendant again placed the children in harm's way and plaintiff assumed the children's primary care. That defendant sporadically exercised parenting time with the children at various motels. That plaintiff is unaware of the suitability of defendant's present housing. However, she has pushed a relationship on plaintiff's 10-year-old son with an 11-year-old neighbor girl, which by recent social media postings is physical, as well as allowing the minor child to be on TikTok, even though he's not old enough to do so legally. All of this has been objected to by the plaintiff as harmful to the best interest of the children. The court needs to assess the harmful impact that defendant's conduct has on the moral well-being of the children. The established custodial environment may not change, but the harmful impact on the children may be irreversible. We're asking the court that the recent child support recommendation of the Jackson County Friend of the Court seems to have perked defendants' maternal instincts to obtain overnights, that the well-being of the children should be paramount and not what may generally be presumed by the Friend of the Court or MCL 722.27A1 to be in the children's best interest. So we believe that, long story short, we believe the Friend of the Court got accurate information from the plaintiff. She just doesn't like the support that's been calculated. If she wants to have a hearing on it, that's fine. But as far as the parenting time, we've got video, we've got social media, and she's got this 10-year-old in a relationship with an 11-year-old girl. My client is totally opposed to this. This is morally improper. And then he's on TikTok, and my client's told her he's too young to be on there. It's not healthy for him. What are you doing? And she hasn't stopped. She hasn't ceased. So I think Mr. Clay is entitled to protect the well-being and the moral environment.
I got to hear. Thank you. All right, son. Good job.
Anything further, Mr. Navarre?
Your Honor, this is obviously the first I've heard of any of this. But I certainly think that if you want to send somebody out from the front of the court to have them make a determination whether my client's housing is unsuitable or unfit or suitable, we have no objections to that at all. And as it relates to the payment on this, I used my firm credit card. I've got a confirmation number from G2Gcharge.com, which is the cloud solutions providers to allow credit card payments for motion filing fees. This is post-judgment, paid $100 on January 27, 2021. As it relates to my client, that she signed a verified motion and has made specific factual allegations that the children do enjoy spending parenting time with her, that they aren't complaining about the environment, they enjoy themselves when they are having parenting time with their mother. And there's nothing that's inappropriate or unsuitable about her housing to allow her to continue to conduct overnight parenting time. And as it relates to the calculation, the Friend of the Court utilized the wrong annual ordinary medical. It should have been, because that changed in 2021. So there should be two support orders. One would be from the date that you ordered this retroactive, which was in early March of 2020 to the 31st of December, using one ordinary medical, which was in place then. And then going forward for 2021, the second order should enter using the current changed annual ordinary medical.
So, Mr. Navar, you make an eloquent argument with respect to parenting time and that reasonable rights of parenting time establishes some kind of threshold, and your client's not getting that, therefore she should get it. But what have you told me has changed? What changed circumstances have occurred? What would justify me revisiting the issue of parenting time since it's already been determined, presumably based upon the very standards that you have announced?
Judge, it changed based on her being displaced from her housing and not having suitable housing to exercise overnights. She has suitable housing to exercise overnights. That clearly is a change in circumstance. Clearly Shade versus Wright applies. And the children have expressed a preference to have more time with their mother. She's desirous of exercising that. She has the proper accommodations at her father-in-law's residence where she resides. And the children have spent, many overnights there with her for a significant period of time. And so I think that is, that's the change, Judge. She's got suitable housing for overnight. She should be afforded reasonable rights of parenting time because she has the suitable housing. If she didn't have the suitable housing, which she was displaced, somebody was running a meth lab in a duplex where she was residing in the upper level and the lab was in the lower level. They condemned it, the city of Jackson did. She was displaced. So for a significant period of time, she was exercising parenting time with the children by renting rooms in motels so that she could have overnight parenting time. That's clearly a change in circumstance, Judge. And I think that she really should be, and the children should be afforded what their rights are, what their reasonable rights are, to have the strong relationship and bond and love and affection through parenting time. The presumption's there, it's statutory. The court has to consider that. And, as to the allegations that Mr. Conant has made today, this is the first that I've heard of these allegations. And I don't know how to respond to those, but we have made some verified factual allegations that the court should consider and respect the arguments of both counsel, but promote what's in the best interest of the children. And we feel that it's appropriate for her to be afforded the parenting time she's requested. The court wants to make that contingent upon suitable inspection by the friend of the court. We have no objection to that, Judge.
Well, if I may, Your
When
Honor.
was just a second, Mr. Conant. Mr. Navar, when was your client displaced from her housing?
Judge, if I may refer to my pleadings. March of 2017, Judge.
16. The order was granted in 2017.
Okay, the order was granted in 2017. It was in 2016. There was an order that entered giving both parents alternate weeks during the school year and alternate 2 weeks blocks during the summer. And then by stipulation, it changed in March of 2017.
Hold on, Mr. Clay, don't speak.
I'm sorry, I'm sorry.
So in 2016, she was displaced from her housing. When was the current parenting time order entered?
March 2nd of 2017, Your Honor.
And that order was entered based upon the circumstance of her being displaced from her housing?
By stipulation of the parties, Your Honor.
And here, 4 years, nearly 4 years later, her argument is, I now have suitable housing after 4 years, and therefore I should be granted additional parenting time. Is that your argument, Mr. Navarre?
That and it's the preference of the children to have more time with their mother, their mother, Your Honor.
All right, Mr. Conan, you wanted to respond further.
I just wanted to indicate that inspecting the plaintiff's home is not going to reveal the fact that she's got these kids on social media, that she's got the child on TikTok. She's got, we've got pictures of her son with this neighbor girl at 11 years of age. The girl is, son was 10. This is not all right with Mr. Clay. This is not what he wants his kids. It's not even legal to have for the kids to have a TikTok account at his age.
All right, so here's what I'm inclined to do. I question whether or not this change of circumstance is sufficient, but since I've got a motion in front of me and I'm hearing some concerns that if legitimate would probably result in me reducing, not increasing mom's parenting time, I am going to order that there be an evidentiary hearing. And at that evidentiary hearing, I could expand mom's time, but I also could reduce it if I find out these allegations are true concerning the social media. That is very concerning to the court, particularly the involvement of the other young child. If Mr. Navarre, and I agree that if the sport was calculated incorrectly, it needs to be corrected. We'll address all of that at the same time. And if I do change the parenting time, we'll incorporate that as well. So we're just sending it back to the front of the court once. So Mr. Navarre, if you would submit an order that the court is going to schedule an evidentiary hearing, leave a blank for the date. Once I get that, I'll have Dawn get a hold of both of you and we'll figure out a time where we can get it scheduled.
I'll prepare that order and I'll send it over to Mr. Cohen and we'll enter that on a consent basis, Judge.
Okay, thank you.
Thank you, Your Honor. Appreciate it. Thanks,
Thank you,
Phil.
Mr. Cohen.
Yep.
And Mr. Navarre, I think you're on the Smith versus Murphy matter. Let me see if.
Can I sign off, Judge? Am I supposed to sign off, Judge? I just didn't know if this one header was over.
I'll take care of that. You're all set, Mr. Clay. All right, there's Elise Murphy. Let me see if Mr. Smith is in here somewhere. Doesn't appear to be. Mr. Navarre, have you heard from any other attorney on behalf of Ms. Murphy?
Your Honor, I received an appearance and a verified answer to the motion from Mike Weed.
Okay, I see Mr. Weed is here. Let me get him in.
My client has been in the waiting room, Judge.
Good morning.
Morning, Mike.
Good morning.
Good morning, Mr. Weed.
Yeah, I just filed my appearance just the other day and my answer. I emailed it to you as well, Your Honor. Kind of came into this kind of just the other day, so.
All right, well, it wasn't in the file. It's not in the file currently. If you emailed it, late yesterday or early today, I wouldn't have seen it anyway, because
I think I emailed it out 2 days ago.
Yep. Mike, I think you used the wrong email address.
Oh, was it?
Yeah, I think you did. Because there were a whole bunch of people that were CC'd on that, and I looked at that, and I think you used the wrong email address for the judge.
Okay. My
if you're gonna email it to the court, Mr. Weed, don't send it to me. Send it to Dawn Sherwood.
I did.
And/or Peter Veldkamp, my law clerk.
I think I sent it to, I know I sent it to Dawn. I'm not too sure if it got sent to Peter.
Well, and Dawn's been off for a couple days, so she wouldn't have seen it. Thank you, Shannon. All right, well, in any event, I'm looking for Mr. Smith. I don't see him in here.
Judge, he says that he's on his wife's computer, Danny Leiter.
Ah, well, that helps. I do see Danny Leiter.
That's Mr. Smith, Judge.
Yeah, apparently people don't realize they can change that name pretty easily. Okay, Mr. Smith, can you hear me?
Yes, good morning, Your Honor.
All right, looks like we've got everyone here. Shannon, Ms. Murphy's present, Mr. Smith is present, and both counsel. Yeah, I'll grab it in a second. So, Mr. Navarre, this is your motion.
Yes, it is, Your Honor. I have some preliminary matter that I need to address. Our motion consisted of 28 paragraphs of properly pled allegations, and the verified answer filed by the defendant has paragraphs 29, 30, 31, 32, 33, and 34. Those are not pleadings. They don't comply with the court rule. MCR 2.110 defines pleadings, and it indicates that no other form of pleading is allowed. MCR 2.111C talks about the form of a responsive pleading. We filed a motion. We made specific factual allegations. Defendant's paragraphs 29 through 34 are prefaced by defendant further states. They're not responsive to the factual allegations in plaintiff's motion. Defendant can specifically, explicitly admit a pleading, deny a pleading, plead no contest, or state lack of knowledge to form a belief as to the truth of the factual allegation. And these paragraphs 29, 30, the paragraphs 29, 30, 32, and 34 are what defendant believes or questions. Paragraphs 31 and 33 are non-responsive factual allegations. 31 says defendant has a history of abusing alcohol. 33 says plaintiff has attempted to indoctrinate the minor child with atheistic ideology in an effort to dissuade the minor child from pursuing her desire to become a worship pastor. These allegations are non-responsive. They don't comply with the court rule. They're not proper. We haven't received proper notice of these allegations. If she wants to file a motion and make factual allegations to which we can then have an opportunity to respond, she can go ahead and file a motion. So because they don't comply with the court rules, and they are court rules, Judge, they're not suggestions. And because we didn't have proper notice, those paragraphs should be stricken from the answer that was filed in accordance with MCR 2115B. The court may strike all or part of a pleading not drawn in conformity with the court rules. It's clearly inserted. Our position is for prejudicial purposes, and no consideration or weight should be given by the court. It should be disregarded, and they should be stricken. So that's our preliminary matter, Judge. And
Let me address the preliminary matter, Mr. Navarre.
thank you.
If you had read MCR 2.110, which defines pleading, it says the term pleading includes only, emphasize only, a complaint, a cross-claim, a counterclaim rather, a third-party complaint, in answer to a complaint, cross-claim, counterclaim, or third-party complaint, and a reply to an answer. No other form of pleading is allowed. This isn't a pleading. This is a response to a motion. If you're arguing that a party who's responding to a motion can't assert counter information, I find your argument frivolous. So whatever request you've just made, I am denying. So move on to the merits.
Thank you, Your Honor. Your Honor, I know you've had an opportunity to review the motion. We allege that their defendant is in a relationship which involves domestic violence. That's paragraph 1. They deny that. Their denial is untrue. Lead plaintiff to his strictest proofs. Allegation number 2. She's made several posts on social media confirming the same, the domestic violence. They deny that as being untrue and leave us to our strictest proofs.
So let me stop, Mr. Navarre. What
Yes.
you've alleged, if it's true, if there's domestic violence present that's impacting the child, and it always does, I think that's a sufficient basis for the court to revisit the issue of custody, parenting time, and domicile. Mr. Weed, you obviously deny that those things are true, and you have some affirmative factual allegations, which apparently the defendant denies. It sounds to me like we've got a dispute of fact. How do I resolve that without simply ordering an evidentiary hearing? Why shouldn't I do that, Mr. Weed?
We understand your position and where we're the trajectory of things. It's just that this is quite blown out of proportion. That may be just my opinion, but a lot of what's alleged, being like dental neglect, school neglect. It's just this child went to a dentist appointment in December of 2019. And then, most of us go every 6 months, some go to every year. But I don't know about you, Your Honor, but I had a very difficult time rescheduling my dentist appointment. In fact, it felt like I had fur growing on my teeth to a certain degree, because it took so long for me to get into the dentist. And when they finally did get me in, after I called them every day, because I was that guy, everything was fine. But in this case, this child had a cavity, and the filling has already been done. In the case of schooling, the opposing counsel, his client is well aware that they were homeschooling this child, because there was a time period from when the school closed, and they were trying to figure things out, come back from, spring break, and we're going to possibly reopen. Well, they didn't. And then they closed indefinitely. And then it took them until April 24th to even have any kind of curriculum to allow these children to learn over line. And by that time, they'd already agreed to that they would homeschool. And even the plaintiff, the father, was in agreement with that, because it allowed him more opportunity to exercise parenting time, in which he did do that at the beginning, but then didn't follow through. He sees this child once a month, maybe sometimes twice. So this is just seems to be coming out of nowhere. There's no police report attached to this motion or anything.
But what you're talking about, Mr. Weed, is a dispute of fact.
Gotcha.
And even if there were a police report, I couldn't assume that the police report is accurate or inaccurate. What's alleged is serious and concerning. He still has to prove it. If it didn't happen, obviously, I'm not going to grant any kind of relief. And you've asserted some affirmative matters that would cause the court to, in fact, seriously consider whether or not the modification to parenting time should go the other way, which I'm certainly free to do if I undertake an evidentiary hearing. But I can't resolve disputed facts at a motion hearing.
Judge, I agree with that, but I would like to edify you as to what they have admitted in response to our motion. In paragraph number 4, we allege that defendant posted on social media, quote, Chris drugged me down the road on the car and I'm pretty beat up, close quote. She has, in her response, admitted that. We allege in paragraph 5, defendant posted on social media, quote, I am in so much pain, I think my foot is broken, close quote. In their response, they admit that. We have photographs of her on social media. She posted, we say in paragraph 6, a photograph of her on crutches with her right foot and lower leg in an air cast and brace. She has admitted that. And so
Mr. Navarre, are you suggesting that I can just simply order a change in custody and parenting time based upon admitted allegations? Don't I have to consider the best interest of the child when I do that? How do I avoid an evidentiary hearing?
Judge, I don't think you do, but I think that that you have the ability in a situation like this where there is alleged domestic violence. She admits that she's posted these things on social media. She admits the photograph of her with braces and crutches, and she's posted on social media statements stating that she sustained these injuries because of acts of family violence perpetrated by her husband.
Would object to that. That's not what she said, and that's not what we admitted.
Hold on a minute.
You're taking things out of context.
Hold on a minute. I'm done. I'm ordering an evidentiary hearing. Mr. Navarre, submit a proposed order with a blank date. I'm moving on to the next case.
Thank you, Your Honor.
Thank you, Your Honor. Appreciate your time and consideration, Your Honor. Mike, I'll send that over to you.
Thank you, Your Honor. Thank you.
Okay, let's see. I think
Justin, I'll give you a call.
All right, thank you.
Tested. I've got a couple of pre-trials. Let me get those done. Let's see. Papin. And Hotchkiss. Good morning, gentlemen. Lazaroff versus Lazaroff. I realize this is a pretrial. I normally do them off the record and in chambers. I'm not going to shut everything down to do a short pretrial. So keep in mind you're being live streamed and we're on the record. Does it look like we're going to have a trial here? And if so, how long is it going to take?
No, Your Honor. I think we have an agreement. Craig
Just
Papin.
a second. Just a second. Mr. Papin for the plaintiff, Mr. Matt Hotchkiss for the defendant. Sorry, go ahead. Shannon has to make entries in the log, so I wanted to make sure she had the information.
Thank you, Your Honor.
You've worked things out?
Yes, Your Honor.
Wonderful. Do you want to schedule it for a pro-con or what's your pleasure?
We would be happy to offer the pro-con right now if you want. We can finalize this.
Absolutely. Let me see if Mr. Lazaroff,
Mr. Lazaroff is in my office, Your Honor.
okay, and I see Ms. Lazaroff is here. Let me get her in.
Thank you.
Thank you, Your Honor.
All right, Shannon, Mr. Pappin's client's with him. Mr. Hotchkiss's client, Crystal Lazaroff, is on the Zoom hearing. Ms. Lazaroff, can you hear me? Oh, hold on, we don't have an audio connection with her yet. Ms. Lazaroff, you can hear me? Looks like not. Looks like she's having trouble establishing a connection. I've got a video, but I don't think she can hear me. And ma'am, can you hear me?
She can't get the, here it is.
I've got the little signal again. Ah, looks like, nope. First it looked like it, then it didn't. Now it does. Ms. Lazaroff, can you hear me? Nope. Yeah, it keeps popping in and out. Says it's connected now. But I've gotten that false warning 3 times now. Ms. Lazaroff, are you able to hear me?
She might not have her speakers on. Yeah. Matt, could you text her real quick just to see if she's got her speakers turned on? Because it looks like she's otherwise connected audio-wise.
I can. I believe that she's using her cellular phone for it, so I'll text her and hopefully she'll get the message, even though she's on there.
Yeah, I don't know that she's actually fully connected. I can actually call her and let her participate that way if you give me the number.
Absolutely, Your Honor. Are you ready for it?
Yes.
It's 517-581-9212.
Hello?
Crystal Lazaroff?
Yes, sir.
This is Judge LaFlamme. Since you're having trouble connecting, we thought we'd just get you present by phone. Your attorney is present, as is Mr. Lazaroff and his attorney. Mr. Lazaroff, would you raise your right hand, please? You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your full name for the record.
Alexander Philip Lazaroff.
Go ahead, Mr. Pappin.
Thank you, Your Honor. Alex, you signed a complaint for divorce on or about August 3rd, 2020. Is that correct?
Yes.
Were the allegations at that time true and remain true today?
Yes.
At the time of signing, had you been a resident of the state of Michigan for at least 180 days and a resident of Jackson County for at least 10 days?
Yes.
Has there been a breakdown of the marriage such that the objects of matrimony no longer exist and there remains no reasonable likelihood of reconciliation?
Yes.
To your knowledge, is Crystal pregnant today?
No.
Now, during the course of the marriage, there were 2 children that were born of the marriage, Riley and Elizabeth. Is that correct?
Yes.
And you have read and gone over with me a proposed judgment of divorce. Is that correct?
Yes.
Now, in there, it outlines, and I'll just point out some highlights here, that you would have enjoy a joint legal custody of both children, joint physical custody of Riley, but you would be the primary physical custody of Elizabeth. Is that correct?
Yes.
And you'd be alternating parenting time for Riley on a weekly basis?
Yes.
Now, the defendant mother's parenting time with Elizabeth would be every other weekend. Is that correct? Every weekend. Every weekend, excuse me, every weekend. Yes. Okay, very good. And holidays and other events as agreed or as a default, the friend of the court handbook, is that correct? Yes. Now, under the proposed judgment of divorce, the marital home known as 222 Smith Street in Rides Junction would be awarded to you if you pay Crystal the sum of $20,000, and then she would then execute a quitclaim deed to you. Is that correct? Yes. Now, there was a business that was involved, family business named Smoke City. Now, the parties agreed that the sum of $5,600 from the wind down of the family business would be defendant mother's share of the business. Is that correct? Yes. Now, an additional $2,000 from the business wind down proceeds would be held in a business checking account to pay outstanding bills and costs that haven't been received yet. And any remaining amount as of February 28th next year, 2022, would then be divided equally between the parties because there are some tax considerations. Is that correct? Yes. And then that would be the final resolution on this matter, and each party would otherwise hold each other free and clear from any further claims. Is that correct? Yes. Now, in terms of vehicles, you have a 2011 Ford F-250 and she has a 2016 Ford Escape. You would each take possession and ownership of and free of any claims of the vehicles that are in your possession. Is that correct? Yes. And concerning personal property, the personal property has already been divided and you each take the personal property you have in your possession with no further claim from either party. Is that correct? Yes. And we understand that there will be a restoration of Crystal's maiden name, or she will have the option, which is Miller. Is that correct? Yes. Now, you've read the proposed judgment of divorce, heard the highlights on the record today. Do you believe this to be a fair and equitable division of assets and debts? Yes. And you could go to trial on this, and you could do better at trial, or you might do worse. But understanding that, you still want the judge to enter the judgment of divorce. Is that correct? Yes. Your Honor?
And I can't remember if you asked this. All of the living children born or adopted during your marriage have been identified in your proposed adoption judgment of divorce. Yes. And to your knowledge, is Ms. Lazaroff pregnant? No. Ms. Lazaroff, can you confirm for the court that you are not pregnant?
Definitely not pregnant.
Thank you. Mr. Hotchkiss, do you wish to voir dire your client?
No, Your Honor. Thank you.
All right. I'm satisfied with the proofs. There's been a breakdown in the marriage to the extent the objects of matrimony have been destroyed. There remains no reasonable likelihood that the marriage can be preserved. Mr. Hotchkiss, can you confirm that the terms placed on the record are indeed acceptable to your client?
I can confirm that, Your Honor. They are acceptable. Thank you.
Your
All
client.
right. What I'll do, I will change your trial date to a status conference. And as long as you have judgment of divorce submitted on or before that date, there's no need to appear.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you all. Have a good day.
You as well.
Your Honor. Thank you all. Have a good day.
You as well.
Okay, next up is Mosley versus Mosley. I see we have Melissa Mosley and Lee Mosley both present. Can you both hear me?
Yes, Your Honor.
Mr. Mosley's screen is frozen. I wonder if he can hear me.
I can text his mother. He's sitting next to her.
All right. Okay. Mr. Mosley, can you hear me?
Yes.
Okay, good. We're here on a pretrial. What I determine at a pretrial is whether or not it's necessary to have a trial. In a divorce with children, the typical issues that would be disputed at a trial are custody, parenting time, child support, and division of property. You folks have a temporary custody order in place. Is that acceptable, or do one or the other of you wish to change that?
We both are fine with the custody agreement.
Is that correct, Mr. Mosley?
Yes.
All right, and have you already divided your personal property?
Yes, sir.
Is there any dispute over who's responsible for debts remaining from the marriage?
No, Your Honor, I think we'll just take care of our own.
Okay, and do either of you own any real estate?
No, Your Honor.
Okay, normally, in normal times, I would tell you, you need to prepare a judgment of divorce, take it to the friend of the court, get it approved, and then bring it back to me so that I can divorce you. But to expedite this today, what I'm going to do is fill one out for you, if that's all right.
Okay.
So, let's see. I need to take some testimony from you, Ms. Mosley. So would you raise your right hand?
On my right hand.
You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your full name for the record.
Melissa Ann Mosley.
Ms. Mosley, you filed a complaint for divorce back in August. Was everything in that complaint true at the time that you filed it?
Yes, Your Honor.
And is it still true today?
Yes, Your Honor.
According to the temporary order I'm looking at, there are 3 living minor children born or adopted during your marriage to Mr. Mosley, Dominic, Michael, and Hannah. Is that correct?
Yes, Your Honor.
And no other minor children were born during your marriage who are still alive?
No.
Are you pregnant today?
I am, but it's not Lee's.
We have to address that, ma'am.
Okay.
By law, that child is presumed to be Mr. Mosley's child. And in order for me to change that, I have got to take some testimony on the issue. So let me ask you, do you know who the father of that child is that you're
Yes,
currently?
it's my fiance.
marrying? Okay. Is there any possibility that that child could be Mr. Mosley's child?
Absolutely not.
When is the last time you and Mr. Mosley had marital relations?
The middle of October. The child was conceived in January.
I see. So you're not very far along. You must have just found out that you're pregnant.
I literally just found out.
Okay.
Congratulations.
Mr. Mosley, can you confirm that you could not possibly be the biological father of this child?
100%. Confirm. I haven't touched it since October.
All right, and you both want me to make a finding in this judgment of divorce that the child that Ms. Mosley is carrying now is not your child?
I didn't know until you just found out.
Okay. Well, I have to say something about it because, like I said, the child even conceived during the marriage is considered to be your child unless there's a judicial determination otherwise. So right now, I'm going to put in the order.
You can't see this. I'm live on Facebook. What? No, I ain't live on Facebook. I just signed in with Facebook. I ain't never touching her again. I told her that when I come back from North Carolina. I was done with her.
All right, Mr. Mosley, I don't think you want that. I'm going to mute your microphone. We're live on YouTube, so I don't think you want those kind of conversations broadcast. Okay, so I put in my provision in the judgment. Plaintiff is pregnant with a child who was conceived in January 2021 and is not the biological child of defendant.
Correct.
So that's why we ask that question.
Right.
Is to make sure that you don't ever have to come back to the court and try to get something undone. Ms. Mosley, are you still residing at 1106 Oak Brook?
No, Your Honor.
Let's see, I see an address. Well, I am going to need to put your correct address. Do you mind giving that to me now, ma'am?
It's 800 South Martin Luther King Drive.
Yeah, we take them off.
And what's your zip code?
49203. I'm around the corner from you right now.
Mr. Mosley, can you tell me your address, and you'll need to unmute.
85 Lucy, Jackson, Michigan, 49203.
Yes. And I realized I spelled the name wrong, so I got to fix it.
UI?
I was talking to my clerk.
Oh, apologies.
Okay. Ma'am, do you wish to have your last name changed?
Yeah.
Yes.
To what?
Rose. My maiden name.
For a couple weeks.
I know the one that was in jail.
That's his daughter's.
Where's one big?
What, baby?
Where's one big?
Because he's got older ones too. He's got a little baby too. Did he bring the baby? No. Go out there, baby, so I can finish this.
You understand?
Yes.
Emma.
Enough. Enough.
Okay, I have filled out your judgment of divorce. I do find that there's been a breakdown in this marriage. To the extent the objects of matrimony have been destroyed, there remains no reasonable likelihood the marriage can be preserved. And you are officially divorced, folks. We'll make sure you get copies of this.
Thank you, Your Honor.
You're welcome. Have a good day.
You too.
Happy birthday, Hannah.
Okay, Shannon, you can take us off the record. I need to take a little break.